Right about the streets.
Leader, they want to hear from the mayor. If y'all ain't learned that yet, the mayor, not the trustees that don't do nothing, that only run their mouth. Y'all don't do no work, Y'all
hide the money, y'all. There's poor people around. With your broke ass.
Every election. So now, because they can't beat me, they got to do this smear campaign to convince public opinion that I'm bad for them.
So you said 2 elections. You were first elected in 2021?
No, 2013 was my first election for trustee. I was a trustee. I sat where they are.
Right.
That's why I know the law.
Council.
Yes.
Elected mayor 2021.
Yes.
Terms 4 years?
Yes.
Okay. Plans of running for re-election?
I'm running for both my seats. And I'm going to win them.
So, and when is the election for Thornton Township?
2025.
So those elections at the same time?
They are.
Bullshit. A bullshit. A bullshit. A bullshit.
Now, all you crackheads, out!
I could not be here breathing and be comfortable if I was really as bad as they was making it. You know, nobody could be around me. So for me to be this calm, I must have some kind of inner peace. And my inner peace is knowing that once everybody take the time to really see what type of person I am, you'd be surprised that I stuck around this long.
I have to make the life that I do live as happy as I can and try to do the best with what I have. You know, live the best life I can live, be as happy as I can be. Nothing is perfect for anybody. I don't know.
Bulls, I swear, I think I figured it out. You know why they don't want us redneck brothers and sisters and the hood brothers and sisters getting along? You know why? Because we'd be unstoppable. I'm telling you right now, we would shut shit down.
Yes. Guess who's back? Yes. And what we'll do, shut shit down. All right. So today basically is going to be a follow-up to what we were talking about yesterday. Let's go into Pablo's. Let's put this on the screen real quick because these businesses are still suffering. And one thing that I want the people to understand is that these lawsuits are going to follow the new administration and continue to affect the people. So this is Pablo's. What I'm going to do is let you know that this is going to trial. They tried to get the case dismissed, and we're going to go over each one from 12/20 and bring you up to date to what's going on right now. Hit the like button. I know y'all wanted to know what was going on with Pablo's. And again, this is going to be split up because this is going to be my last live until the weekend. So this is going to be split up for the people who can't hang for both of them. Just hit the like button. Hit the like button. All right, now, so this is basically a status report. And this status report was on 12/20/2024, kind of trying to see where we were at with everything. And I'm just going to scroll down to the bottom where there's a general type of discovery. This is where the case plan was coming into act. So a general type of discovery, a date for Rule 26, and we're going to go into Rule 26.8.1, first date by which to issue written discovery, the fact discovery, completion date, because there's a time that you, by there to here, where you have to get all the evidence over, not like what they did in the YSL trial, just kept adding shit as they went every day. It was ridiculous. That is not how a trial's supposed to go. Both parties supposed to know what each person has to represent so they could basically stand up for each other. So the expert discovery completion date, including dates for the discovery of the expert report, any expert witnesses, a date for the filing of the positive motion, and with respect to trial, they're going to move forward and whether the jury trial is requested. So after all of that, they do discovery, start exchanging stuff. This is after they've been having hearings and they've been putting motions in. They've been trying to negotiate, and we're going to let y'all see where the negotiations kind of fell through. Well, on what date or whatever. So after this, hold on, what day was that? Oh no, sorry. Yes, after this, there was a motion that was filed by the Village of Dolton in support of its motion to dismiss the plaintiff First Amendment complaint. So they're trying to get some things dismissed, and we're going to just kind of go into it a little bit so y'all can get an update. Plaintiff does not have the property interest in its business license. This is some of the things that they were trying to address to get some of these counts removed. And it's not happening, or the whole case dismissed. And that's not happening because Pablo's went through the same thing that Yvette Towen went through, getting run down on. This is when Lacey was doing all of this BS. Within this broadcast, we're going to read to you Lacey's response. And he has to affirm everything that he was saying because they're moving forward with the proceedings. Okay. So here we go. Plaintiff fails to sufficient alleged municipal liability. So the Village of Dalton, this is their response. So the plaintiff, the allegation fails to give sufficient amount of information, putting the liability on a municipality. Plaintiff has pleaded itself out of court as the municipal liability. The contentions of the First Amendment complaint affirm that the Village of Dalton has failed policy-making authority. The Village of the Board did not revoke plaintiff license. The Village Board did not cause plaintiff constitution deprivation. So it looks like they're trying to pull the board trustees out of this. Okay. The relevant allegations are as follows. The Board of Trustees for the Village of Dalton govern the body responsible for making decisions and setting policies at the local level regarding budget, local ordinance, license, land use planning, all overall community development, among others. And this is how they're trying to pull the trustees, and I think they're trying to get the trustees out of it. Because you see how, you got to name everybody. Like in that lawsuit we just read, all those people could get themselves pulled out. Okay, if their lawyer makes motions like this. Okay, so the village may not revoke license or shut down properties for lack of the same without first receiving approval from the village board, and no formal vote has been taken by the board regarding the revoking recommendations. So according to the well-plead allegation of the First Amendment complaint, plaintiff has failed to assert a municipal action that was the movement force behind plaintiff constitutional injuries as required, and that's related to the board. Plaintiff argues in that response belief that its allegations, Mayor Henyard was an official within policy-making authority. So they're trying to pull Henyard out of this as well, and this ain't gonna fly. Now, I can understand the board members because the board members never voted on it, but Henyard, she directly involved in this. However, there is no citations to facts containing in the operative complaint that supports the theory or place the village on notice that the plaintiff proceeded on such a theory. Again, if you put conspiracy, you got to say what the person did. You got to say, like Miss Williams' case, the one that was connected to Alexis, the reason why she got off with conspiracy so well, because she showed the sequence of events of Henyard telling Lacey telling the other cop, and then they violating her First Amendment right and her freedom to protest. Does that make sense? It was stated in the complaint. So why they contesting this? Because if you don't say it, it didn't happen. So we like, hey, you didn't even pull Henyard in here in your initial complaint. And I wonder, did I say that in the first Pablo's video that we read? Video when I read it, because I usually highlight when things like that is missing. You know that. So that's why they have this back and forth. That's why it's good for your lawyer to write it up properly and save some time. Does that make sense? So they saying that Henyard was the final policy maker, appeared nowhere in the final amendment complaint. The lone response brief is that Mayor Henyard is the local liquor commissioner by statute and ordinance, and therefore must be final policy maker. While plaintiff may rely on new facts asserted in the brief, those facts must be contested with the allegations of the complaint. So he has to bring some more facts into that complaint. And that's why I think they had submitted amendment. So claims that the Mayor Henyard is the final policymaker is entirely inconsistent with the well-plead allegation of the First Amendment complaint, which established that the village board, not the Mayor Henyard, makes decisions and set policies as to license. So I don't know if he put in his first complaint that there was a tone, just like the rest of them did say, that there was an underlying law, because if he did say that, he may not have been able to say that, because everybody knows that it's not written that you listen to everything Henyard said and not the actual law, but that's the actual tone. And Henyard is the end decision maker in her eyes because she don't even care what the board says. So moving forward. So plaintiff next argue it has alleged municipality liability through the series of acts committed by the village officials. The only act it relies upon, however, are those that Mayor Henyard and apply to Monell. Remember, we said we had a Monell claim. That's just to connect her as the supervisor and acting in her capacity. He has to give more details and connect it. That's why they told you. That's probably why they didn't want people to know about what conspiracy was, because y'all don't know how to put the pieces together. Am I the only one that know how to put the storyline? Like, wait, this, right there. Write it down, please. Plaintiff does not have any property interest in the business license. So let's see this. Plaintiff responsibility response to the allegation that does not have a property interest in the business license is entirely unclear. While it argues that any discussion about the business license was provided to give color to the allegations, plaintiff plainly refers to the business license and license plural without count. The license, so let me see what it says. It must have been something they wrote up wrong. A license to do businesses constitutes the property interest. The village and Henyard has deprived plaintiff of its procedural due process rights by denying its access to meaningful administrative hearing process prior to refusing to renew or revoke plaintiff license. Plaintiffs respectively request that this court enters an order finding that the village and Henyard deprived plaintiff of his due process rights by refusing to renew his license for no reason. Okay, so the village replied upon allegations that the plaintiff was bringing a due process violation claim based upon both his business license and liquor license. It is now appear plaintiff agrees that it does not have a property interest in the business license and therefore does not have the due process claim related to the business license. So we need to look into that. They have trial, but they're saying property interest. They don't have to own the property to have a business there, but maybe it is some type of miswording that made him say that he owned the place. Maybe he was a renter. I don't know, but we got to clarify that. So plaintiff fails to allege that the post deprivation remedies related to the liquor license are inadequate. So it's procedure. It's procedure errors here in the way that Pablo's lawyers written it up. And I know I had to talk about that before. When we split this up, we're going to put part one of Pablo's there so y'all can get a full picture. I know I mentioned that they messed some things up in the filing. And this is why Pablo's case is going so long, well into 2025, y'all. Just like Yvette Tony. It's ridiculous. All right. So the village has moved to dismiss plaintiff due process claim related to its liquor license because the allegations amount to remedy and unauthorized acts of Mayor Henyard, which requires adequate post deprivation remedies to satisfy the due process. So he didn't say, hey, I want my liquor license. See, you have to state that the people, state the claims, the allegation, the relief. Well, the law and the relief. That all has to be embodied in it. It was some things missing. So he said, you ain't asked for no remedy, so you don't want that addressed properly. That's why they had to do an amendment. They had to amend. And this was on 1/8/2025. Still having to do corrections when this thing been started a long time ago. All right. Conclusion. Plaintiff fails to plead facts that plausibly suggest that the village of Dalton is responsible for the action of Mayor Henyard pursuant to Monell, and therefore the village should be dismissed from the lawsuit. Additionally, plaintiff First Amendment complaint describes random and unauthorized actions by the mayor to which pre-deprivation proceedings were impartial. Plaintiff did, however, have post-deprivations remedies. Okay, and that I want to see what the post deprivation remedy was, to which it availed itself, and therefore no due process violation occurred in the deprivation of the liquor license. So I think he was granted the liquor license on appeal, because I told you guys that they be cheating. They'll do it on administrative level in Dalton, and then the person won't get it, and they'll appeal it on the state level. State level will look at it and give it to the person. And you remember before in Woody's, they won when they appealed, but they still didn't comply with Woody's barbecue. You see what I'm saying? So that's where the appeal, and that's what he's saying. Well, he got the remedy of it, so it's no complaint. Why is it? Man, these lawyers crooked as all hell. All right. That's from Bo. That's from Bo attorney office. That's in representation of this. So now let's get into Rule 26.1 disclosure. So y'all could just kind of know what that is, because that was the next step. They like, hey, that dropped on his face. Obviously, let's move forward. Hold on. What I'm gonna have to do is start to remove some of these things off the screen, so I don't get keep pulling up the same thing. All right. Rule 26.1 disclosure, and that's basically they're going to be given a time frame of when they have to disclose things to each other. So if you ever go to trial, and it's one thing that I had lost one time. I lost, guys. They pressured me. That's when I was first learning law out here in Georgia. That shit hit out here. It's different from Jersey. Jersey, you could go to traffic court and be like, I'm taking it to trial today, stand there, handle your business, and win. These motherfuckers out here, they had 2 prosecutors against my black ass, but this is how they tripped me up. I had all my paperwork filed and everything, but I was still practicing how to basically do my opening statements and things. I was learning it. I ain't have all of that together. And then they was like, well, you just need to be ready in the next 24 to 48 hours. The judge may call you. So he just called me out of the blue like 2 o'clock in the afternoon. Man, I went down there, and what I did not know, because they didn't a prosecution, this was a ticket. Shut up, y'all. I fight hard. Yes, because the judge said, I never see somebody write so many motions for a ticket. I said, because I needed to know some things and file some things. I didn't say that. But basically, where I messed up at was that I asked the prosecution here, or the attorney that prosecute these tickets, for certain information of what they will be presenting to me. And they didn't. So that day, I didn't really know law a lot. These was a couple of years ago. And they was like, well, you want to go to trial today? Well, we could push it to next month. I mean, a couple of weeks. And But they was like, she gave me the option, but it was like, in my head, I was like, I just want to get this over with. I'm ready. I'm prepared. But they got me on the opening statements. The judge was being a bitch. He was literally cutting me off. And also, they had surprise witnesses that I didn't even fucking know about. How you gonna have? I asked to see the camera of the cop that said that I ran the stop sign, and they're gonna bring the personnel, the representative who retrieve it, and all types of shit. Some dispatch lady was there. I said, "What the whole other side of the fucking court was full," and my black ass in there like, all right, don't be nervous. Don't be nervous. It's like 2 prosecutors. And who the hell is these people? She dressed up and shit. Like, she supposed to be at work. So this is very important, because I was caught the off guard. So if you don't have the Rule 26 disclosure, and we're going to go in it, that moves on into the discovery. So basically, disclosure is supposed to start February 3rd, 2025 in this case. First day by which to issue written discovery is set February 17th, which is already 3 days ago. And now proposal for fact discovery completion. They have till August 22nd. You see how many months this is? This is going to be well into the next administration. Am I lying? Or I'm flying? Proposed deadline for pending. So by September 26th, they have any amendments they had to make to complaints and all types of stuff need to be done near, because they probably be moving on to trial. Okay. Plaintiff anticipated that it may need an expert witness in order to prove reputational or loss of business damage. Proposed completion of expert discovery is October 17, 2025. Okay. This is going to go well into the next. So if y'all want to know what happened with Pablo's, we here for it. We're going to get into Rule 26 real quick, but we're just going to put the last page up, which is the longest page. And this has basically the response from Lacey Lewis. Damn it, I forgot to bring his picture up there. Fucking frack. Okay. Oh, shoot. All right. So Rule 26 is the duty to disclose general provisions. Okay. So generally expecting by Rule 26 or otherwise stipulated or ordered by the court, a party must without await discovery request provided to the other party. So that's when discovery is starting to come. The name, if anyone, known of the address, telephone numbers of each individual who have discoverable information along with subjects information, disclosure parties that there's going to be supporting the claims of the defense needs to be starting to put on the line, a copy and a description of the categories of locations, all documentation, electronic store. They need to know where is that, how they're going to get it, is it going to be numbered, where they get it from, everything. So that is Rule 26. That's where it starts to basically opens Pandora box to what's going on. All right. So just one more. They had, this was, I don't need to show the paper, but on 1/16 it says, enter before the Honorable Judge Cummings, the court adopt the party's proposal for case scheduling. And we went over the case scheduling. They talked about Rule 26A1 disclosure, and they went into all the dates that we just talked about. Okay. Now let's hit it. Please hit the like button if you like what we talk about here, how we break down the facts and make it make sense, baby. This lawsuit, okay, was ostracized by Tiffany Henyard, not Kamal Wood. Orchestrated, I do apologize. I did pronounce that wrong. Let me put it on the screen. I'm look at the bigger one and put my glasses on. This lawsuit was orchestrated by Tiffany Henyard, not Kamal Woods. How you know? They both stupid. They both did something dumb. Henyard admitted to calling off the police department to provide security. Think about it. Also, there is a report video that shows everything from the left and rear of the altercation. All right, y'all still talking about the other thing. Wonder when they will realize, or are they waiting for someone to offer money? Henyard is as popular as a bird grill. Yeah, we read that one already. You also had that girl with the braids. We read that already. Let me move down. Hold on, y'all. Talking about the knee pads. Hold on, y'all. Let me see if there's anything new that you got here. Dang, Grace. Okay, so we said that. Hey, Honeymoon, thank you for being here. Hey, Miss Sharp, thank you for being here. Anyone shared on Dalton Politics? Anyone shared on Dalton Politics? Share what on Dalton Politics? Hey, y'all guys, don't share my stuff on Dalton Politics. No disrespect to Dalton Politics. I love them. I love the information they share, but I don't want any room for error. I don't want any drama. Sometimes I set a tone off on people who don't want to hear the type of truth that I give, and I really don't have time for it. Continue to let the algorithm push me through as though it has. I don't beg for attention, so I don't mind. Do not share me on Dalton Politics. I give Dalton Politics respect, and I give them kudos, and I tell you guys to go there and participate because it is an amazing group. But I know when my presence rattles bells, and I don't have time for it, okay? I'm going to just say that. I love you guys. It's still a sensitive situation because my goal is to make sure that my baby girl get justice. So with that goes to say places where I'm not totally wanted or accepted, I don't push the button. I stay away and I let the algorithm push us. So share me somewhere else in a whole nother group. I love you, but please don't. I love you guys. Only the real gonna understand what I'm saying. I don't beg for nothing, and I don't like being restricted. So if I have to do that, I'll choose not to deal. But I love what they allow to come out. But my stuff be a little bit too heavy for they liking. All right, so this is Lacey Lewis' response. Okay, now he has to reaffirm some of the things that has happened. So this right here is basically just going to give us a briefing or a rewind of what happened. Hold on, let me see if I got Yoshi picture up there. Hold on, because I did have pictures of Henyard with the cops, but I had took them down because it was just so many pictures. Jagged. The pictures that I had Henyard with the cops, they actually had Yoshi in there. And y'all know who I'm talking about. Lacey Lewis, them little ass arms. Let me drink some water. I'm getting thirsty. All right. So now, answering affirmative defense to plaintiff First Amendment complaint. I love you guys. I'm thirsty. Hit the like button. Please let me know if Tiffany actually put something on her page, because we're going to share this shit today, because I'm not going live until later on this week. So y'all getting the best, giving you the best that I got. And y'all know I'm going to edit it, break it up to keep y'all entertained throughout the weekend. So jurisdiction and venue, let's move forward. Parties we already know is PABLOS CAFÉ. Is the Illinois Limited Liability Company. Defendant Lacey lacks sufficient information to either admit or deny. So these are some of the questions that they were asking, like, do you know of this? I want to get to some of the juicy stuff. Defendant Tiffany Henyard is the mayor of Village of Dalton and the liquor controller commissioner. This is Lacey responding. Defendant Lacey limits the allegation contained in this paragraph. So some of the things basically he's saying he don't know. He's saying he don't know. So we're going to kind of go into it. Now, other entities. This is him giving affirmation to. It says the Board of Trustees of the Village Board is a government body responsible for making decisions and setting policies at the local level regarding budgeting, local ordinance. This is number 9. Licenses, land use plan, and overall community development, among others. Answer: Defendant Lacey admits the Board of Trustees is a government body. So he either saying he don't know or he do know. So I'm kind of want to go through this to go to the factual allegations, because this is Lacey kind of responding to this. Plaintiff began operating a bar restaurant March 2025. Lacey doesn't know. Plaintiff has a Class D liquor license expired April 30th, 2023. Liquor license for the property, which allowed plaintiff to serve alcohol. Defendant Lacey admits the allegations contained in this paragraph, so he admits that he knows that. Plaintiff also has village license, business license, which also set to expire April 2023. And the reason why they're asking him this, because when they go in to question them throughout the trial, if anything is different from these transcripts, that's when they're gonna be like, gotcha. So if you didn't know or you did know because you're trying to change your statement, this is what you answered here. So plaintiff also has a village business license, which was also set to expire April 30th, 2023. Okay. Plaintiff also has the state liquor license, and defendant Lacey lacks sufficient information to either admit or deny. This is big because your actions that you made should have been definitively made over you knowing that this man didn't have no license, because you did some bullshit to him, and it made the news. This is the one that made the news. Do y'all remember? Do y'all need me to play the video to make this more exciting? Yeah, because this is the one with the police where they had, as soon as because he talked against Henyard on live, and then the next day Lacey came and shut it down, and it was a big problem. Upon information, okay, so Dalton is the home of rural municipality within Cook County. Some of these things is just, So on April 15, 2023, plaintiff filed an attempt to pay for his renewal application for license within the village in that the license was set to expire April 30th. So 15 days before that, he tried. Defendant Lacey lacks sufficient information. This is what he's saying. It says the village of Dalton, the village accepted the license. Lacey saying, I don't know. But these are some of the things that has happened. So they're trying to put these facts out here again. We're about to get into the discovery phase. Okay. Consistent with the historical practices and as affirmed through the verbal communication with agents of the village, plaintiff was allowed to come or continue to carry on the business pending the issue of license. And that was the same thing with what was it? Woods Barbecue, where they gave him a backdated license and a check that was expired. Yeah. Lacey says he don't know. So May 2023, one of Pablo managers, George Meach, placed several phone calls to the village inquiring about the status of the license. On several occasions, representative for the village of Dalton did not answer the phone call. And on other occasions, representatives of the village stated that plaintiff license is in process, pending, or stated that the village will call him when it's ready. Lacey lacks sufficient knowledge or don't admit either to admit or deny. But his actions showed that he supposed to knew this already. Instead of telling me that the police department goes through no verification process when it comes to what Henyard say it is and just run with it. That's why it's important for us to talk about this, because it's highlighting some significant issues. Ms. Meach was never told that there was any issues with the application for the licensees. And I think Lacey's will not know this. But if he did his research as the sergeant and to know the history of what was going on with Henyard and all of this stuff, this is something he should have done. And that is also part of my investigation with the Lexi story. This is going to trickle into, I love you, police of Dalton, but it's going to also trickle into the credibility of Dalton Police Station, their practices, and their chief of police regulating their actual command center correctly over investigations and over things like this. They didn't follow the investigation procedures correctly in many aspects that we're going to talk about on Lady Broadcast that has to do with Alexis. So I know he ain't follow shit. Henyard said, yeah, get him. And he said, okay. He don't need a warrant. He don't need to see shit. He just busting down on them. Okay, let's move forward. Okay, so near or in June 2023, following yet another inquiry by Mr. Meach, village representative Mr. Meach to call the village administrator Keith Freeman, or the village attorney Delgado, in which Delgado was not named in this. I know you think you could name an attorney in this lawsuit. Somebody educate me on that, because Delgado was named in one of these lawsuits where he played a role, him and his buddy played a role in the licensing. And I believe this is it. I think this is the one. Yep, I think this was the one. So Mr. Meach did call Freeman on numerous occasions. Freeman, however, did not answer or return the phone call. We're going through the facts here. Lacey says he does not know. Mr. Meach also telephoned Delgado on numerous times, not only just Freeman on many occasions, but did not get any response from the law firm to issue insurance or licensing. Lacey does not know. On July 5th, 2023, Village Inspector Kim Austin, dog. Oh my God. I should have had the clip. This broad is named in this too. I forgot. I'm going to just say this, and I'm going to have to repeat this. Forgive me, God, and it's not the Sabbath or Friday. I'm going to give y'all a little bit mess, but according to Jay, she was a prostitute. Shut up. Is known, allegedly. And she came in between them. She came in between a situation with Jay and Henyard as well. She said she don't know if it was her whispering in your ear or if it was Leotis pillow talking. Okay? All right? Yeah, we had to talk about her, Miss Austin. Defendant Lacey lacked sufficient notice about them phone calls, or the inspector, it says, was telephoned by them. He don't know. So this is her name again. I told you, when it comes back up, she got to go. She have to go. So again, 20 minutes after Meach received Austin, it is Alston. It's Alston with an A-L, Alston. Phone call. PD officers Jermaine Lee and 46 police PD officers arrived at the property. Lee told Mr. Meach, "We are shutting you down." This is where it get a little juicy, for not having a local liquor license. Okay. So after 20 minutes after calling Miss Alston, she outed him. Okay. To the popo. It said, "He ain't got no liquor license. Hurry up and go over there, lock him up. We ain't issuing." Woo, the setup is real. She has to go. People, she directly against y'all. So, moving forward, defendant lacks sufficient information to either admit or deny that allegations. He say he don't know. Lacey like, "I don't know. I plead the fifth. Lee further stated, "Go to the village tomorrow and talk to him." And defendant Lacey said, "I don't know about that." So the Dalton Police Department officers also arrived at the property on July the 5th. Did not give plaintiff any document, official or otherwise, regarding the closure, nor did the Dalton Police Department offer any stickers or closure notice on the front of the door of the property or elsewhere. Now we're getting a reiteration of what happened. Lacey said he don't know. Prior to July 5th, 2023, plaintiff have not been given notice that it might be shut down for the reasons that its liquor license had not been renewed, or had plaintiff received any update from the village concerning the status of the license. From July 6, 2023 onward, Mr. Meach and his wife, Miss Neach, went to the village of Dalton every day to speak with the village employees who could assist plaintiff with its license or explain the closure of the property. And I will say this, y'all gonna have to be mad at me. Y'all remember that y'all saw Mr. Meach coming to the village of Dalton's meeting. He went there 3 or 4 times talking about the situation. So this was brought to everybody's attention and the trustees. So but I know they can't force people to do their jobs. I'm going to be honest, but this was happening a long time ago. It was happening. So at no time was Miss Meach or Mr. Meach given any answer about the renewal status of the application or renewal of the license, or any information concerning the forced closure of property by DPD. Lacey, everything I just read to you, Lacey said, "I plead the fifth, I don't know." After July 5th, 2023, closure, plaintiffs sought and filed an appeal of the closure with the Illinois Liquor Controller Commission. Plaintiff was closed by police department from July 5th to October the 3rd. So they setting that up so they can let y'all know they lost some money. Damages are starting to occur. On October 3rd, 2022, Robert Collins, former police of Dalton Police Department, chief of police, sent an email to the Dalton Police Station, stating, "Please be advised that Pablos and Angels will be allowed to operate." So this is when Collins got the hell in trouble. Y'all remember? Then he got fired. Yup. He said, "You spending too much money. Shit is getting crazy here. We ain't doing it." That's when Lacey was probably kissing ass trying to get his position. And Lacey was doing all of this backhanded shit to the businesses. And when he got tied up in these damn allegations, he was Henyard's best friend, her right-hand man. You got dirt on me. I got dirt on you. We could be friends. Yeah. Yeah, that's how they get down there. No, nada. I don't like it. So at the July meeting, Mr. Meach, because he went to the July meeting, I'm telling you, he was there a lot of time. Mr. Meach asked Henyard about the status of plaintiff license. Henyard responded that the village would issue the license, but they were pending and would be issued as soon as the village internal process was completed. I remember that. He went there in August as well. Now, this is stating what we just said. He went there several times and it was not a lot. So he went there August as well, him and his wife. Henyard was present August meeting, said the same thing to him. He was waiting around. Henyard again responds to the village will issue the license pending internal affair issues. In September 2023, this was July, August, September, Meech attended another monthly meeting. Henyard was present. Again, at the September meeting, Mr. Meech asked Henyard, what's up with the license? Henyard said village would issue the license, but they were pending. Same dumb excuse. October, did it again. Henyard said the same thing. All of this right here that we just read, Lacey response, defendant Lacey lacks sufficient information to either admit or deny the allegation contained in a paragraph. I'm pleading the fifth. I don't know. So from April 30th to November the 2nd, plaintiff license were not renewed by the village. Plaintiff was not given an explanation for the denial and renewal of the license. Plaintiff was not given an explanation about the DPD officers closing the property for not having a liquor license. On November 2nd, 2023, Allison, there she go. Miss Fast Ass in the Pants. Fast Ass in the Pants. You're fired, broad. I'm tired of your name. She served plaintiff, so she served Pablos at the property with a packet of documents which was received by employees of the plaintiff. Lacey, I don't know about that. Plaintiff was served with a certificate of receipt, which acknowledged receipt of attached notice of hearing to revoke renewal business license. This is going to go into Delgado and them tricking him. I promise you. The certificate includes 2 case numbers. They have them there. The caption of the certificate stated, proceedings to revoke or non-renew village adult and business license and liquor license. So 2 different case numbers, attaches the case numbers there. Again, Lacey don't know none of this, but you went there and ran down on him. He's still saying, I don't know, I can't admit or deny this. But this is part of your job. And even though he wasn't the chief of police, I would assume he was the person that carried some of this stuff out. And Collins was supposed to verify this. Yeah, it's supposed to be some verification going on. So the charge alleges 31 indictments that the village complaint warrant the revocation of the non-renewal plaintiff license. And that's what we're not going to read through all of those. That was the longest part of that reading. All those allegations were allegations. There was nothing directly connecting Pablo Cafe to the incidents that they're trying to say. They were saying that it wasn't renewed because they had fights, people were drunk, all types of shit was happening. We read each one of them, and none of them was either backed up with the police report. Person was fighting with their boyfriend and girlfriend in the parking lot. Shit that had nothing to do with nothing inside of it. None of the reports that they talking about here, they were all allegations, and they had nothing to stand on their face. And these are all of the charges and allegations. And we read all of these before. These are some of them. And they were ridiculous. Like the last one, a noise complaint was made. And they trying to put that on Pablo. This is how ridiculous this is. A noise complaint was made. Vehicles were playing music loudly in the alley of the property. A woman complained that the security guard at the premises threw her to the ground and she feared for her life. This woman was determined to be an unruly patriot and had been drinking. It was determined that she was wilding. Y'all made that determination. But you blame it on them when people go there to get drunk. Yeah, moving forward. This is some of the things that we're going to have to look for in a trial. So we're doing a reiteration. And guess what? Pablo, and guess this is all for Lacey to know. Lacey like, defendant Lacey. This one is that. Which one he admit? This one, upon information and belief, defendant Lacey admits the allegation were listed on the charges. So all of those charges that they gave, those the ones that wasn't significant, Lacey agreed to that. He said, I know about those. Oh, yeah, I know about those. Yeah. Defendant Lacey admits to the allegation contained in this paragraph that the village had number 11 class liquor license for him, I would assume. Finance. I don't understand, like, I don't understand that term for that. All right, so Lacey lacks sufficient information, either or admit upon information and believe village liquor license has been issued and such no new Class D license was issued unless the existing Class D license expired, is non-renewed or revoked. He said he don't know nothing about the liquor license. He can't say yay or nay, but I'm going to run down on you. I'm going to keep saying that because the police, this is their behavior. This is why we have to highlight them. And now throughout this whole time of drama, nobody addressed the police station. Nobody addressed Dalton Police Station. Nobody addressed that you have a killer cop that's still getting paid by Dalton, Illinois. And I'm not going to say allegedly because I'm still waiting for the Freedom of Information request for that one Freedom of Information request. But y'all paying these rogue ass cops to this day. But nobody's addressing it. But I'm going to take a whole glass and shut the hell up and mind my business. All right, let's move on because this is kind of a long document. We halfway through, guys. Hit the like button. This is a reminder what's going on with Pablo's. Y'all wanted to know. Here we are. This trial will be going on into the next administration. Get ready. Okay? Y'all going to be seeing Grace Levi until the next administration, dog. Okay? So, now this is regarding of Henyard motive. Henyard used to charge to non-renew or revoke plaintiff license without first delegating her authority as a local liquor commission to anyone else. Lacey, like, I don't know about that. The village initially exaggerated and trumped up the charges so Henyard could use the recommendations regarding plaintiff license to be used or misuse her authority as the liquor license commissioner to revoke plaintiff liquor license. And that's in regards to the complaints of people being drunk, fighting out there, Lacey, like, I don't know. But you should know because you ran down. And you just said you know about all of those things that you admit to that long ass 33 account or whatever of incidents, but you don't know about this. Now, this is who we got to look into. This is Delgado friend. See, this is where Delgado come up in here, but they didn't name him in this. Michael Casper was appointed as a hearing officer for the proceedings. This is what I'm telling you guys. This was allegedly Delgado boy. Upon information and belief, Henyard appointed Casper as the hearing officer. Delgado acted as the attorney prosecuting the charge on behalf of the village. Casper has previously represented Henyard personally and has acted as lead counsel in matters of Henyard versus municipal officers of Village of Dalton in 2022. So Casper already have a relationship with Henyard, representing her, but now you're playing as the hearing officer. Let me drink some coffee. Do y'all see the bias here? I'm so done with her. Thank you, y'all. We got it all. Because of our amazing team tonight, we got everything we need to keep y'all entertained for the weekend. I'm sick of Tiffany. I'm sick of her wasting my damn time. So as we were saying, Casper and Delgado was playing double duel at this liquor hearing to basically push Pablo's out of the business arena by orchestrating him losing his business. But as we know, I think on appeal, he received it. And that's what they were talking about administratively, that he had relief. So upon information and belief, Casper and Delgado were both hired in 2022 by Elk Grove Village regarding an anonymous billboard. A hearing was held on charges on January 26, 2022. The hearing to revoke non-renewed plaintiff business license. So he talked about where Delgado and Casper worked together before. And not only and then it says also Casper and Delgado actions as co-counsel on included but not limited to all of these cases, 3 cases, 4 cases. Oh yeah, that's when your lawyer do your research. He may have made some mistakes with the filing, but he definitely knew, oh, I saw y'all at this court cases. So the bias, it's the bias for me. Right. And the people have to suffer for this. Let's move forward. Plaintiff only received a hearing transcript after filing its initial complaint. Okay, so this is what happened at the hearing. All right, so at the hearing, the following Dalton police officers were called to testify in support of the charges. Remember all of those charges? Officer Mathis, Officer Clark, Herrera, Malone, Gillio, Newsy. I'm saying that wrong. Newsy. I'm probably saying that name wrong. These are some of the officers that testified on some of the incidents that I told you that either did not have any police report connected to it and or did not connect directly to Pablo's. Just because there is a place that sell liquor, like most places that do sell liquor and cause people to be intoxicated, and it is legal, they're not responsible for that person's behavior. Period. If nothing happened inside the shop that would cause liability to that place, that has nothing to do with them, and they trying it. So these are all officers that testified. Do Lacey Short Arms know about this? Defendant Lacey lacks sufficient information and either admit or deny the allegations that these officers made. All right, cool. At least you took a whole glass to shut the hell up. Neither Delgado nor the testifying officers offer a single document, and this is what I was talking about. A single document into evidence in support in the testifying officer's testimony. Waste of fucking time. Defendant Lacey lacks sufficient information about that either. 2. Upon information and belief, the testifying officers did not testify as to any specific date, time, names, and complaint parties, or any other relevant foundational information that would support his testimony. The majority of what the testifying officers testified to occur in the parking lot of the property, which is located in multi-businesses commercial strip mall. So it's not only Pablo's there, but other stores are there too. So he's like, we all got to take the liability. And what Lacey say? I don't know. Upon information, belief, clerk testified in a manner that was completely inconsistent with the testifying officer, stating that she either did not remember any of the incidents of Delgado inquired with her about or the incidents that occurred. So the clerk was there and she said, I don't know about none of these incidents, basically that was recorded that would justify his license being revoked or suspended. Mr. Meach also testified at the hearing. He testified that the police were only present at the property approximately 10 to 12 times per year. Casper issued a recommendation under the case number 10 to revoke plaintiff business license. Casper, the hearing officer, that is Delgado friend that would work for Tiffany, that had plenty of cases with Delgado. Let's remember, this is so damn biased, okay? And as Lacey say, I don't know. So let's kind of move forward a little bit. Although the recommendations did not reference the testimony of the clerk or Gillio or Casper, stated that the officer's testimony was consistent and uncontradicted. Upon information, believed defendant Lacey admits to the quote. Yep, what my officer friend said was the truth. Anything, that's that line. Y'all see that line right there? He gonna stick with his officer friends no matter what. He like, I'm gonna stick with them no matter what. It's just a line. Now, when it comes to her, I don't know. But these half-ass statements that they saying with no police report, 100%. Right. This is the line. This is the tangle web that we weave. Okay. We get to 17. We almost done, y'all. We finishing up this live. Thank you guys for being with us. Love you. You know what we do here. Deep dives. Hit the like button. Okay, so Casper concluded that in order for Mr. Meach's testimony to be credible, so basically Mr. Meach had testified that it was only 10 to 12 times or whatever. Upon information and belief that testifying officers did not lay any foundational, or certainly did they not present any documents that established the time of any allegation incident occurred to support the interference, that plaintiff was the only party that could have been responsible for the occurrence in the parking lot shared by several commercial businesses. Lacey don't know. Casper concluded that in order for Meach's testimony, which was the 10 people, to be credible, the hearing officers would have to conclude that the village and the other testifying officers had to be completely fabricated much of their allegations. So he said, basically, for me to believe you, I have to, in all theory, say the officer's lying, and I'm not about to do that because they can't be lying because they got blue on, and we put a badge on them. So guess what? You about to lose your license, and that's exactly what happened. So upon information, belief, Casper knew that the village of each of the testifying officers had completely fabricated the allegations against plaintiff. The village of Dalton meeting scheduled for February 19th, 2024 was canceled, and the village board therefore did not vote on the business recommendations. Upon information on the belief, the village of Dalton would have voted against the business recommendation by voting 4-3, allegedly, because Tiffany had her people on her side. And I think that was Andrew Holmes. Was it her? And Brown. Who else was on her side? Because I don't know how they would have had 4-3. But y'all tell me, because I'm getting a little tired. We're getting down to it. So it's commonly understood that certain village trustees are loyal to Henyard, and the other 4 are opposed to her agenda and the actions taken by the mayor. So the other one was Andrew Holmes, Brown, and am I missing somebody else that was on Henyard's side? Let me look at your comments. I don't know. But anyway, let's move forward. So Dalton police officers often sat in the parking lot of Dunkin' Donuts located directly across the street from plaintiff business, so those officers can monitor the property. Dalton police officers was in the Dunkin' Donuts parking lot watching property on February 19, 2024. This is at the time where Fox Chicago visit plaintiff at the property to inquire about allegations that plaintiff license was being held up for political reasons. Now, this is how the next day they came with the official notice to shut him down. And I think they caught, I think this when Fox and 5 caught some footage. So let's finish read this so we can reiterate what went on. So on the same night, February 19, 2024, Fox Chicago broke the story that agents from the Federal Bureau of Investigation had questioned at least half a dozen people, including a business owner and a former Dalton employee, and the elected official as part of an investigation into Henyard. On February 20th, 2024, the same Fox Chicago reporter drove to visit the property again and was followed by Dalton police officer. Yeah, I remember reading that because that was egregious. That was out of control. They were following the people with the damn cameras that could really put them on live news. Okay? But nobody talks about what happened in Dalton to their police. Their police is just good. They made hundreds of thousands of dollars on the backs of y'all through Tiffany, but nobody want to check the shit. I ain't saying they all bad, but the system is broken. That's all I'm saying. That's all I'm saying. Let's go. Yeah, I'll email you. Why we can't get in contact? I thought I emailed you before. All right, so let's just finish this up. On February 20th, 2024, Lacey and the Dalton Police Department arrived at the property. This is after they followed Chicago news to the property and gave Mr. Meach a finding of fact and order for the other case number of revocation order. This is what was caught on the news. Lacey stated that Mr. Meach, that if Mrs. Meach did not sign the revocation order, he would arrest them. And you cannot do that. You cannot do that. The revocation order was signed by Henyard and prioritized authority revoking pursuant to the code 3-317. I'm going to go and check that by law, but this is this ordinance. This is not even a civil complaint amongst two parties, no injured victim, nobody hurt. So if someone was to, like the officer issue a summons, I don't think that you're supposed to get arrested for this. I know your signature is a form of receipt, but regardless, your case, even though you don't get it or you don't come in some aspects, they will find a way to serve you in a third party way and then hold you in contempt of court or make you lose. So to say I'm going to lock you up for not signing this when it's ways to present this by certified mail and things like that is egregious. Does that make sense? He said, if you don't sign this, you're getting locked up. That is against the law. Okay. So revocation of license. This was the appeal. The president of the Liquor Control Commission shall has authority to revoke the license issued. And this is the Village of Dalton Code. So he's asking Lacey, does he know about this? And Lacey said he lacks sufficient notice to admit or deny about the liquor code and the appeals action and things like that for revocation. Lacey stated that Miss Meach that he would be arrested if anyone else removed the sticker as well. As of the day of the filing of this amended complaint, because I told you they had to amend it before, and they may have to amend it again, no formal vote has been taken by the board regarding the recommendations. The revocation order does not provide for any appeal rights or provides any information on how the plaintiff could appeal to the revocation. So that means that he don't have his due process. Remember, Fourth Amendment due process, they're supposed to allow him to appeal the decision after that fake hearing. The village may not revoke license or shut down property for lack of the same without first receiving approval from the Village of Dalton. So plaintiff business is being interrupted and damaged based on approved above actions and allegations. So the thing I would say is that even though we stated that he went to all these meetings and the board knew by seeing him talk, there was no physical thing put on the agenda. There was nothing ever put there as far as his license being looked at or anything. Now, I don't know who does the initiation of that, but I would assume because Mayor Henyard is the boss of the liquor license, that's why her ass and her friends look the hell like this.
Now, all you crackheads, out!
I would say that maybe the Village of Dalton trustees had nothing to do with that. But they have took initiative most recently in this coming months to make sure that things got done that they could not get done. And that was after the time, I believe, that House got the right to be mayor pro temp. You see what I'm saying? So I ain't covering up for the trustees, but there are some situations here that people need to pay attention to as well, that their hands are tied until they get themselves in a position that they did have control, because she wasn't doing what the hell she's supposed to do. Okay. So there was no adequate remedy of law to compensate plaintiffs absent injunctive relief. So defendant Lacey's don't know about this. Plaintiffs will not be able to be remedied in the business of operating as an ongoing concern if defendant's actions are not enjoined. So they're trying to put an injunction on the situation too onto the police so they could stop harassing the business when he do get his license. They parked outside doing crazy shit, putting things on him that he has nothing to do with, creating a profile on him, allegedly at the clerk office that don't exist, have her come testify to, I don't know what the hell you're talking about. But that part, that's where the injunctive relief is coming in. Not only because I want my license and y'all gonna owe me for some money loss, but we need these actors, official cops to stop the ones that are acting under the guise of Henyard. And I want to clarify, these cops, they're not terrible people. But I will say, just like I say about who Janet Johnson is, Keith Freeman, anybody who I say is acting in official capacity and then you getting bullied to act a certain way, I don't care. You have the right, you have the duty to do right. Pick your shit up and leave. So you have nothing to do with injustice and unhonorable interactions in your career. This is your career. Once you're said and done, y'all have to move on in your career. She has tainted y'all career. Lacey is done. He's retired. Yoshi is retired like this. Ain't got no damn choice. Hoping that the pension kick the fuck in. Don't know how old he is. All right. So The count of violating due process was reviewed again. We know what that is. We're on page 22. I'm trying to wrap this up. And that due process has to do with him being informed of his license being revoked in the process. Because all this time he was calling, talking to all these people. Miss Alliston, the alleged prostitute, shut up. I'm sorry, God. I don't like throwing out mess like that, but it is the alleged. That's what Jay had said. He said it's on public record. I didn't get a chance to go look it up. But y'all see me all guilty. I hate doing that, but it's the truth. She got to go. All right, so just following up, let's finish off. Violation of First Amendment, that's freedom of speech. On February, I guess that they're talking about freedom of speech and political association. So as stated on February 19, 2024, PD officers followed Fox 5 Chicago. So that was part of his freedom of speech. And that's going to be documented on a public platform because he had the right to talk to Chicago News, which time PD police Lexi gave plaintiff the revocation order. The revocation order was retaliatory in that there was no rationale basis for the revoking a plaintiff liquor license without a notice of the hearing or hearing in front of the local liquor control commissioner. Other than the fact plaintiff principally spoke with Fox Chicago the prior day. Okay, so we have finished where we're at. These are the claims alleged, we put out there. They were basically asking Lacey Lewis, do he know of all of this? And they're asking him because when it comes down to trial and cross-examination, they can use these answers against Lacey, where they said, okay, so if you didn't know if these licenses actually revoked or actually active, were you acting in a lawful capacity to move forward what you did? Who gave you the authorization? What gave you the authorization? Is it the actions and the research you did, or was it Henyard? And that's where the conspiracy comes in. So does that make sense why I read this whole document? We kind of put it together on why it was important for them to put this on the glass. We already know that we're going into the discovery phase of Pablo's. We know that Pablo's is going to be actually in lawsuit, litigation, in trial, all the way to 2025. Trial probably starting again. I think I took it off. Probably starting sometime after August, because the completion of the discovery components is supposed to be August 22nd, 7th, 2024, as per the document. I am not, because we didn't finish your other video. Y'all want to finish it? No. I'm not about to stress y'all out. We 2.5 hours in. We did our due. I'm not about to play with my head, because Henyard she sickens me. I knew I came in late and wondered. Yes. Okay. Thank you for being here, Honeymoon, Best of Us, as well as I Am That One. I Am That One, as well as my help in the back, as well as we do have another family member that let us know in the audience that she was live, and I just wanted to give them a shout out. It was someone else, but thank you so much, because we were able to capture every single thing. So again, this is what we're going to do. We're going to be doing a recap this weekend. Y'all won't see me live until Sunday. We're going to break this into 3 different parts, okay? We're going to break this into 3 different parts, and you guys are going to watch it on the recap where it makes sense. Yes, it was only that I am. So it was only I Am That One. She was the only one. But I thought it was somebody else too, but I know she was the first, definitely. So I love you guys. I appreciate you guys. For loving what I do. Without y'all, I actually will be half of nothing. Y'all know I'm a striver. I'm going to keep on striving. But y'all definitely help me be on point. I promise you guys. Y'all know who I'm talking about. I have a lot of strong, beautiful, independent women that actually support me. That support me in the background, which has given me, how can I say, strength and hope to believe that there's good people still around. Honestly, I'm a little traumatized. The people who talk to me knows that I'm traumatized with dealing with people. But these people who have been in my background, ladies, I love you guys. I love you guys. I pray for God to continue to protect y'all. Strength and peace to all of our new family members on this page. And we're going to ride out with some Hebrew music, dog. We got to put God in it. I know I be cursing, but forgive me. Forgive me. May Lord. I love y'all. Gotta go.
Breath aloud, y'all. Eyes up, and every knee gon' bow, y'all. Respect the music, for the words, you got life in it. Let there be a firmament, you put lights in it. Satan, but the waters is your footstool. Every tree yielding fruit, that's that good food. You put lights up in the heavens for season and days. And now years too, we trying to get back to the ways.
They want to hear from the mayor. If y'all ain't learned that yet. The mayor, not the trustees that don't do nothing, that only run their mouth. Y'all don't do no work, no work.
I'm Cara Wilson. I'm the mother of Alexis Wilson, killed by Dalton, Illinois police. At the time that my daughter was killed, Tiffany stood in front of a microphone much like this and said that she stood with the cops and they did do the right thing by killing my 19-year-old child. Not only did she not take those words back, she didn't offer her condolences. She's never said anything. The first thing she did was hire this group of security guards to surround her and PR. So the real reason Tiffany has security is hiding from accountability about what she said about Alexis Wilson.
Drunk as yeah, スライドするお前の地元にスライドするスライドする
Imagine if my small business blew up overnight and I woke up to some sales.